Thank you very much, Chris. That was a wonderful introduction. And also the invitation was very much appreciated as I was there in Canberra, and I was really eager to see what you guys are up to here. Um, it's been a few years since we worked together, but Chris and I, as you said, we go back to 2013. We were some of the first academics that started this discussion about platform governance, trying to promote what back then was the famous multi-stakeholder approach. And I think it has some value also in the discussion that we're going to have today. In Brazil, this approach was very much taken to heart and led to the creation of a law, internet law, that was based on a consultation, public participation. My center, the center that I'm working on nowadays, it's the Center for Technology and Society, is the platform that was created. So they provided an online site, which at that time was quite revolutionary to collect insights about how to go about regulating the internet from a variety of stakeholders. And this participatory process really inspired me to go to Brazil and study the pros and cons of this process, because as we will see, in a way, it was inspirational. It led to a very interesting set of principles. But then as we learned through the passing of time, the enforcement considerations tend to be neglected. And also multi-stakeholder processes are often hijacked by stakeholders who are more resourceful than others. So I think we were back then already some of the most vocal critics of multi-stakeholder processes. So it's good when it's done well. Now, we don't see everything on the slides. I don't know if we can, to some extent, adjust.
If someone has insurance, we can adjust that. But otherwise, it's the classic case of they set this whole thing up and it confuses.
Okay, and I'm also one of those classic person that talks about technology, but is terrible in fixing. So I will leave it to your imagination to see what's written there. So a little bit of introduction about myself. I'm born in Italy, but I feel very much as a global citizen. In Europe, we have this program of exchange called the Erasmus program that brought me to Barcelona. And then after that, it was very difficult to go back to traditional provincial life in my wonderful city, Padua. So I started traveling all over the place, and I ended up in the Netherlands and then in the UK, where I met Chris. And as part of this global community, I got to hear about this fellowship in Brazil that led me to do this postdoctoral work there. And then I fell in love with Rio de Janeiro, the whole environment, and quickly enough, then I came back several times, and I was hired by the law school in 2020, at the beginning of 2020. I moved there, and it's an exciting place to be right now. There's a lot of booming things that are happening in the technology space. And also you can see a lot of what I'm going to talk about here today. So attempts to replicate some of the dynamics of regulation that have been seen in Europe. Europe has been the front runners in many of these digital governance aspects. And on the other hand, you see that there's much more resistance to a bureaucratization of the digital space that we can see in Brussels. And so it's a very also timely moment to be there and be doing this work. Also, I must say, regarding the academic involvement, in Brazil, there is much more opportunity, I feel, for academic involvement and organizing dialogues with regulators than, for instance, in the UK. And so I think that's a good inspiration for us.
FGV is amazing. So
Yeah, so
as an FGV,
Yes, I also included the obligatory promotional material about my university. It's a very good university there. We have just created an office in Europe as well, and who knows, one day we might end up also establishing ourselves here. We have a Center for Technology and Society that I mentioned. There's also a Center for E-commerce Studies that I lead. And we're part of the Law School Global League, so we participate in a lot of these networks, events, and summer schools that they organize. So who knows, maybe our paths will cross again soon. One of the things I put there is also I love to create networks of researchers working on global governance challenges, particularly in the digital space. And nowadays, one of these big challenges is regulating digital platforms, not only from the classic content moderation discussion, but also from an economic regulation point of view. So how do we deal with the enormous power, the economic power that these platforms have? How do we adapt the traditional tools to investigate and tackle the challenges of digital markets? So the talk today is basically about the extent to which we can say that there are platform effects, Brussels effect, and I don't answer this question. I'm going to anticipate now because it's a difficult empirical question in a way. But let's go into the discussion with an open mind and try to distill some lessons from the Brazilian experience. So as you might have heard, the Brussels effect refers to the fact that the rules that are imposed through regulation in Brussels are basically exported in other places of the world. This can be de jure because Brussels, the European Union, enters into treaties, agreements that implicate the application of similar standards elsewhere. But there's also the de facto Brussels effect, which is that in a way, other jurisdictions get inspired by Brussels, they adopt similar legislation, or also the very companies that are regulated, very regulated entities, decide that they are going to export this compliance framework that they developed in Europe elsewhere. And it's contrasted with the Delaware effect was a famous effect in the US where companies are doing a race to the bottom, establishing themselves in the place where taxes are lower, the cost of incorporation of the companies are lower. And it's contrasted also with the California effect. And basically, the Brussels effect is a global implementation of this California effect, which is you have higher standard in a jurisdiction where everybody wants to be, and as a result, companies try to level up the playing field to that. But under the Brussels effect, there's more factors that come into play. There are not just about the global application of the California effect. There's something that Anu Bradford, which is the author, the academic that has created this concept of Brussels effect, uses to explain why this happens. So, of course, economic significance will be something that applies also in the Californian context. Regulatory capacity of the target jurisdiction. This is also quite important because very often the legislations that are passed in Brussels are very complex, require a lot of costs, but also resource in the terms of knowledge and capacity to handle the bureaucratic framework that is not easy to find in other jurisdictions. And there's some political or socio-economic affiliation, so that explains, according to her, also the adoption of Brussels rules elsewhere. So this is different, for example, from what other academics are calling today, Thomas Strains, particularly the Beijing effect. The Beijing effect is other countries around the world are somehow incorporating Chinese standards because Chinese companies are always more present into standardization processes. They are operating outside China. And so the exportation is done in a different way, not necessarily because of affiliation from a political or socioeconomic perspective. Another aspect that is particularly important for the Brussels effect is that it occurs when regulation targets an inelastic component like a consumer market where if you want to operate, there's no other way than complying with this legislation. It's not like regulating capital or labor where you can try to relocate these factors of production and just comply with the rules by being basically outsourcing to a jurisdiction where it's cheaper to operate. But I think the most important aspect is the one that you cannot see, which is the one that I want to discuss mostly here, is the non-divisibility of a company's operation across markets. So the claim somehow, which I'm a bit skeptic about, is that you have a GDPR framework, let's say, data protection framework in Europe, and it's too complicated to divide up your compliance operation and working in one way in Europe and another way in another jurisdiction. And I think in particular in the platform space, if you look also here, there's an example, the platform to business regulation that was passed in 2019 and regulates the relationship between the platform and sellers on the platform, and imposes a bunch of transparency obligations. So if you look at these examples, you can see that in some cases they export the obligation to other jurisdictions, in some cases not. So it's a bit naive to say, in my view, that a legislation will be in its integral part exported to another jurisdiction. Usually what you see is companies picking and choosing and trying to leverage or arbitrage around the edges, you know, the parts that are not completely determined of one law, to argue with the other legislator, maybe in another country, that this has been accepted or is a best practice in one jurisdiction, but actually maybe that other regulator does not agree. So there's a lot of moving around the target to take into account the non-finite obligation, no, the non-determined obligation in the various frameworks. So let's go right into the core of the discussion, which is about platform liability. Actually, so today I want to connect this discussion about internet governance and liability of platform for third-party content with the economic regulation aspect. In the beginning of the internet, we didn't have so-called safe harbors. So laws that were saying you cannot make somebody liable for third-party content. It was traditional doctrines of common law, civil liability, torts that were saying, yes, you can, to some extent, make somebody else liable. Mainly, we use contributor liability. So to what extent you make a material contribution to something that you have knowledge that will lead to either implicitly or explicitly will lead to a harm, or vicarious liability. So you are profiting from third-party activity. You have the ability to control it. Therefore, we're going to hold you liable. So the US company, especially in the early days of the internet, they were very concerned about this because it could lead to the prevention of creation of several sites and applications that everybody wanted in those days, you know. So they went to Washington. They asked for a legislation that protected them from this third-party liability, content liability. They got a safe harbor, and this safe harbor covered user-generated content, so they're created by the users of the platforms. However, we saw already from early cases that it didn't cover content that basically the platform contributes to create. So the famous roommates case was a case where the platforms had a drop-down menu where you could choose your roommates on the basis of race and ethnicity. And this was considered to violate the fair housing law in the United States. And the platform was found liable. The safe harbor, the liability shield did not apply because they contributed to the creation of content. Outside this safe harbor, there was the Section 230 of the Communication Decency Act. There was another safe harbor for copyrighted content. Here, the rule is basically until you don't know, or unless you know, you cannot be made liable. And we presume that you know when you have a notice that was sent to you, and there's a formal process to submit these notices, or where there's really willful disregard for something that should alert you about something illegal that is happening. So with this, in the US, the platforms were a bit relieved. They were safe, and they continued to operate. In the EU, they followed steps of the US. A few years later, they create a similar safe harbor as for the copyright environment in the US, but they applied it to all types of content. So it's a notice-based framework for liability. Until you get a notice, or until you know somehow, you're not liable for third-party content. Now, there was some divergence across member states in the European Union, and this led to the creation of somehow different, what they call due diligence obligations. So in some states, you have to act even when you see a notice on the newspaper that something is happening. As a service provider, you should have read the newspaper, and therefore you know. So this was because of the lack of harmonization. But progressively, the different developments that happened in member states led to the European Union creating due diligence obligations also at the European level. So for instance, the eBay case is a famous one where they said that it can be requested that the intermediary prevents the future upload of the same content that has been found to be illegal, because that's a usual problem. You identify something, it's a whack-a-mole situation, and you take it down, and then the person re-uploads it maybe with another user account. So that was one of the new due diligence obligations. And more recently, with the Digital Services Act that was passed in 2022, we have recognized in the law some of these due diligence obligations. I'm not going to go in depth here, but it's just to give you an idea of how it has evolved since then. Now, let's go to Brazil. In Brazil, we had this law that was created in 2014 that I went to study there. And it was, because of this process, it was also a very principiologic law. So statements like freedom of expression and privacy must be protected at all time. But at the same time, there was a concern for the liability of service providers, content hosts. And here, Brazil adopted a very pro-freedom of expression posture, saying, we are not going to make you liable until you receive a specific judicial order saying that the content is illegal. So that's much strict, goes much further in terms of giving assurance to the companies than the European framework. It's in a way similar to the US framework, the first safe harbor that I mentioned. But I think in this case, you have to consider also one shortcoming, that is, if you are a victim of hate online, anybody has posted a photo that you don't want to see online, now you would have to go to court, and it would take time before online it works much faster than in a court process. So that was a big problem from the beginning, but it was recognized that it's a sacrifice worth having in the name of freedom of expression. Now, there were some exceptions, particularly for revenge pornography, so the posting of intimate pictures, naked pictures, basically online. There you recognize that a notification outside the judicial process is enough to give rise to knowledge and therefore liability. And copyright also, because of the big lobbying that there was in copyright, they managed to get a more interventionist type of approach here. One good aspect about this safe harbor is also that every time that the content was removed, the service providers had to put a notice saying, this is why it has been removed, and this is what the type of content that is missing. Nowadays, Brazil realizes that this safe harbor doesn't make sense anymore because of the massive amount of content that is online, the length of the judicial proceedings, and many people that have been wronged, frankly. So it's challenging the constitutionality. There have been 2 actions before the Supreme Court challenging the constitutionality of this safe harbor. And perhaps you can say that they want to follow somehow the EU approach with the Digital Services Act. But this problem has been there since the beginning. The cases are actually very old, but somehow, and this is something that tells you about the political process in Brazil, the Supreme Court has been waiting for the Congress to act and do something, to pass a law that regulates digital platforms. If in a few occasions it said that it was ready to rule, but then it withdrew the application because Congress started to advance with these bills on digital platforms. Only recently, when Congress said, no, we're not going to manage, we don't get the majority to approve this bill, the Supreme Court came back and said, okay, now this is the last time. We're going to rule, and we have a first vote by one of the Supreme Court justices. We are waiting for the others, and the things are changing. What I mentioned, the legislative process. Let's see what was the main bill that was at stake here. It was bill so-called on transparency, freedom, and responsibility. It's also named the fake news bill. It was born with the idea to tackle fake news. You might have seen, it was a big problem in Brazil, big polarization of society. The elections were probably swayed by fake news on WhatsApp. And as a result, they started drafting a law on fake news, but then it expanded to cover many other things. So it's incorrect to call a fake news law. But now what basically this is the big change for us, that it recognizes that it's no longer just a matter of civil liability for the particular content that you are missing or you are failing to moderate appropriately. It's a matter of basically a process or a system. You need to have your system diligently in place to deal with this massive amount of content. So even if you miss one particular type of content, that's not the only problem. The problem is if you are not being reactive, competent in dealing with the risks that are generated by these platforms. And especially these days, the word that is very trendy, used by Digital Services Act, is the systemic risks. So we are talking about systems that are complex, and you cannot deal with one element only. You have to see it as a whole together. This bill also would propose a third type of liability that is combining the administrative and civil aspects for emergency situations. This is also a little bit of an importation from the Digital Services Act that has a security protocol, as they call it, where the European Commission can request platforms to do something in a time of crisis or emergency. For instance, COVID or election misinformation campaigns. So here they want to replicate, and they put this aspect. Now, the bill didn't go through, but what is interesting to see is that the electoral law intervened with binding provisions that are already in force to basically replicate some of these aspects. So you can see the inspiration taken from Europe, going first to the Congress legislation. Then what is interesting is this electoral commission is formed by judges. Some of them are Supreme Court justices as well. And you might have seen Alexandre de Moraes versus Musk, the big repercussions when Musk was blocked in Brazil, right? It was because of this electoral law that was not being complied with. So this electoral law was updated to take into account the challenges of platforms and the fact that there was no legislation in place to deal, for instance, with fake news during the elections. So here, this legislation, what is perhaps striking is that in the last element, it says that you don't just have a liability for failing to take the appropriate measures, but also a liability if you fail to immediately remove when requested, which is something that goes astray from the idea that it's a process-based liability. Here, what is the new idea about the system-based approach, the system risk, there is a systemic risk? The idea is that you cannot deal with a complex system by analyzing content by content. And here, what they are trying to do with this importation of the concept is to have them both. So you are responsible for systemic risk, and you're responsible for not immediately removing. So what I want to say here also in relation to the Brussels effect is that sometimes the concepts are taken a little bit out of context and they are mixed up. And so it's important not to apply lost in translations framework to other jurisdictions. The other part that you can see there is that similar to the eBay case that I mentioned earlier, the judges can decide to extend a removal order to content that is similar. And we don't know what similar is. This gives a lot of power to the judges to say, yeah, you just have to remove this, period. People have been complaining about the increase of power of the electoral tribunal, but on the other hand, without giving power to this entity, we will be really subject to a lot of political interference, campaigns, misinformation. So it's a delicate balance there. But what this already tells us is that there is a tendency to accumulate powers to deal with digital platforms. And it is important to have safeguards that could kind of limit those kind of interventions. This is the obligation of systemic risk. So as I mentioned, they replicate similar to the European Union, an obligation to identify, assess, and mitigate risk. This comes from the UN Ruggie framework for business and human rights, where initially non-bindingly corporations have accepted to have this responsibility to take into account the human rights impact of their operations. And here in the DSA, it was basically imposed as an obligation to digital platforms. So here also the bill of Brazil tries to do a similar thing. There is this security protocol that I mentioned earlier. So as the regulator can notify the companies in relation to a number of illegal content types, and the companies have the duty to skillfully and diligently remove it. Now, the weak link, the problem of this legislation as was proposed was the enforcement part, as usual. So here, there was no recognized entity that was in charge of enforcing this legislation. There was a big political battle over who should be this authority. The main proponent actually was the telecom authority, which is known for being very permissive in Brazil, at least with regard to some practices like zero rating that Chris can talk a lot about later, I think. But the problem also was that, okay, they tried to deal with the complexity of this world by saying to their regulated entities, you come up with your solution. I mean, we are in a complex environment. The regulator cannot understand all the different players that are involved, the dynamics. So you come up with your own criteria of what you think is good. We're going to validate those criteria with the Brazilian Internet Steering Committee, which is a multi-stakeholder body composed by various facets of society that should be consulted for all internet regulation. And then we will let it go. The problem with that is that the CGI only does a prior check of the code, but does not monitor the enforcement of this code. And all this is very loose. So there was a lot of criticism about this law. And ultimately, it's stalled in Congress, did not pass. And the Supreme Court started ruling the case that I mentioned. The code of conduct potentially would be a good approach for the reasons I mentioned, developing basically using your own capabilities as a platform to address best problem that you understand probably better than other people, including the regulator. But there's also downsides. And the main downsides, I would say, is that you would tend in these codes of conduct to maintain things at a high level so that they cannot be used against you, because these codes of conduct can also be used by consumers in court saying, you are misleading me because you have a code of conduct that says that you do X, but you are actually not fully doing X. So there's an abstract framework. And because these codes are developed jointly by several platforms or several players in the industry, they tend to be, first of all, catering to the interest of the majority, not taking into account sufficiently the minorities, most vulnerable people, the small platforms. And there's a risk of hijacking, what we were talking about earlier with a multi-stakeholder process. So the dominant players, one example just to be concrete, when in Brazil we were trying to deal with this information, they started talking about this code of conduct, and WhatsApp said, why don't we use a limit to forwarding messages up to 10? You cannot forward the message more than 10 times, or I think 5 times, which was something that they were implementing, but that other platforms were not implementing. So what you tend to see is this kind of behavior. The big players that are regulated also elsewhere, they bring in those obligations that maybe are more stringent for big players, and they try through the code of conduct to apply them horizontally. So this can have also some competitive impact, and that's why we should be concerned. And here is the economic regulation part that I wanted to briefly also talk about. Without going into details of the various problematic issues of digital platform and economic governance that we had some cases. Those all the way up to here did not lead to any decision. They did not lead to any finding of infringement. Also, the only cases that actually worked in digital markets, they were a result of a settlement of what they call an agreement of cessation of conduct. And they managed through this consensual negotiation instrument to rapidly deal with some problems that were emerging. But we don't have strong interventions against digital platforms in the economic environment. As a result of this, you have a lot of leveraging, abuses of dominance that might be happening and they're not being caught. And also an important aspect that is also illustrated by the 2 images is about mergers or economic concentrations. Big platforms, especially when we're talking about the big tech firms, they can see the emerging threats more quickly than others. They have more data at hand to do that. So typically they acquire small players in a way that this is done early so that they don't hit the threshold for mandatory notification of these transactions. And in Brazil, especially, there's also, even if you meet the threshold, very often there's something called the shortened procedure to review certain kind of transaction that do not present obvious problems. And so a lot of acquisitions were approved without serious review. So here we have another bill that was introduced to deal with some of these problems of digital platforms. And it starts, like the other bill, it starts by saying that there's a lot happening elsewhere, including in the United States, where we had some important cases and reports, but then looks immediately at the Digital Markets Act, the legislation in Europe that deals with economic power of platforms, and cites Tim Wu, saying that his book, The Curse of Bigness, was illuminated and so on. And this book is actually not just about economic problems from concentration of power, but also about political democracy problems that have to do with that. But this bill doesn't go into that. So once again, you see, you import something, but maybe not capturing fully all the implications of the concept. And then what they do is basically go on and replicate the same categories of platform services that have been regulated in the Digital Markets Act in Brazil. What is astonishing, problematic in this bill, and probably the reason why it this did not go forward is that it adopted a very, very low threshold of what it means to be a gatekeeping platform. And in Europe, you have a threshold of 75 billion euros of revenues in the last 3 years, I think. No, 75 in the last year, or 7.5 in the last 3 years. Here in Brazil, it's basically in the million, 15 million. So they would lead to a lot of gatekeeper companies. One nice thing that they imported from the European framework is a tax on the regulated entities. So you give us work to do, then we're going to impose a tax. However, differently from the European framework, it's not proportionate to the amount of expenses that you generate, but you have a fixed tax every year of 2% to all the regulated companies. So there are some things that could have been improved, but especially I would say that there is this general sense of very lofty, high-level principles that need to be interpreted in a specific case, and we don't know how the authority would go about it. So it generated a lot of criticism because of that. What is appropriate use of data? What is transparency? So these are very difficult obligations to implement. And this framework would be governed by the telecom authority. Once again, this led to a lot of controversy because the competition authority would be more appropriate to deal with this kind of infraction of the economic order. So there was this political debate. In the end, it did not go forward. There was a lot of different objectives that are not the traditional antitrust objectives. They had consumer protection, reduction of social inequality, massification of new technologies. So a lot of interesting things, as you will see in the list of the Marco Civil Internet. But then what is the real biting aspect? How does it come down to implementation then? So we had, fortunately, an intervention by the specialists in the field that criticized this. The CAGE, so the first one is a commissioner by CAGE that wrote an article specifically about this, criticizing the lack of clarity over the objectives of the law that would lead to potential misinterpretation. And then the whole authority submitted a response in the consultation promoted by the Ministry of Finance to reform the framework to take into account the challenges of digital platforms. And as a result of this contribution, where CADE said, yes, we have to regulate, CADE is the competition authority, the Minister of Finance published a final report saying, yes, we're going to regulate. There's a number of suggestions that we have here. So what's the way forward? First of all, it's clear that the safe harbor that we saw at the beginning is no longer, does not make sense, is not proportional, particularly because now we have enormous power that is concentrated. These platforms are able, they have the resources to moderate content much more effectively than back then, so we can impose more obligations on them. The technology has improved. People's dependence on this platform has increased enormously. So we cannot just apply the usual civil liability framework. We need to to recognize that it's a special kind of environment. They're becoming sort of essential for several reasons. And they create a systemic risk. So what we have come out with in this case, but before the Supreme Court, we have submitted an amicus brief with the center, and we said you should create an interpretation of this article of the law that recognizes the economic power and that recognizes that systemic risk happens because of a huge user base, the interdependence of various actors, and the dependence of users on these services. So in all these cases, we suggest that the platform should at least, when they are big platforms that they cause systemic risk, they should have at least communication channel that is effective, where you can get your rights exercised. You have an appropriate moderation that takes into account the systemic risk. And the recommendation system, they should allow the users to understand and control them, because otherwise, basically, they're like broadcasters. and they should be liable for the production of content that they co-create through the distribution. The Supreme Court judge that voted already on the case was very much aligned with our intervention. He went even further, suggesting a number of cases where there should be strict liability of the platform because it's a dangerous activity, essentially. And he said, well, for now, this is our proposal, but Congress should regulate much more in detail what are the circumstances of these strict liability cases. And so that's where we are, basically. And the approach that I think we're going to see facing these challenges from Congress and Supreme Court is, in any case, the platforms are going to have to produce a lot of documentation showing how they meet the challenges, how do they address the systemic risk. And this is called meta-regulation. Why? Because the regulator recognizes that actually the real regulators are the platform. So what meta-regulation does is ensure that we have a framework to review the regulatory activities by platform and basically leverage that to leverage their knowledge and ensure that also other parties that are affected by this platform, so going back to the multi-stakeholder element, are involved in understanding this problem, voicing them out to the platform, and then see what can be done about it. This is in line, by the way, with what the OECD suggests, that you should have participation, experimental regulation, so going back and forth, trying to find the best solutions. And there's a number of downsides that I think we don't probably get into the details of now, but the problem is you also need to have an independent verification of what is being done. So it doesn't solve the problem simply say that somebody will review the platforms. You need to have a framework to make sure that the regulators who is reviewing the platform is doing a good job. And how do you do that? You increase transparency and participation by civil society, by academics, by third parties that can keep the regulators on their toe to do a good job. And the Minister of Finance, in their proposals, kind of goes in that direction, saying that procedural transparency is something that should be applied to all gatekeepers. Then what I think is interesting and what me and my colleagues in the center are working on is to develop procedures for market studies or market inquiries, as they called, or market investigation in some jurisdictions, where you create an ad hoc procedure on certain type of services to try to understand the challenges that they create and what are the appropriate remedies. What we suggest in our proposal that I have a link to at the end is that there should be a participation in this process. But however, the key aspect is the platforms comes up first with the solutions. They invite stakeholders to comment on this, the regulator as well. And then to the extent that they can prove that their remedies are adequate to resolve a particular problem, then they should not be subject to more strict interventions like breakups or forcing sharing or interoperability. You can rely on a self-regulatory framework with transparency and dispute settlement over the application of this framework. And I think this transparency, which is key, needs to involve a number of things that nowadays are not sufficiently transparent. So for instance, now in the regulation of the DSA and the DMA, what is key is user number and revenues. So we define who is caught by the legislation based on that. However, as a researcher, I don't know, how many users a certain platform has unless the platform has revealed it to the regulator. And I don't know what happens between 1 year and the other while they're communicating the new numbers to the regulator. So I think there should be more ongoing process of allowing other parties to also have access to this key information. User number and revenues is one of those. Content moderation as applied is another. So one thing is the formal rules, and another is how they have their internal book, the procedures for operating these rules, what kind of technology they're using, what's the differential impact that these rules is causing on several different groups, what are the methods of training of their staff, and make sure that they understand the local situation. This is a big problem also in Brazil. Very often the moderators in California don't understand the references that are made. You know, Facebook in Myanmar famously was accused of having caused genocide because it didn't understand the jokes, the cultural references that were made. And ultimately, we need to all understand what are the risks and how the platforms are addressing this risk. So there's a number of players that should be involved. And I think we should think about different levels of transparency for these different types of stakeholders. And we are here and we should be definitely involved. This is the proposal that we have launched. Hopefully the QR code is working. And it's an ongoing conversation. Tomorrow we'll have the pleasure to talk the ACCC about this proposal. I won't bore you with the details, so going directly to the conclusion, because there's a number of conclusions that are specific to this proposal, and they're about, you know, the extent to which also private enforcement should be combined with public enforcement, which I think is important here. But the ultimate question, I would like to close with that one, is, you know, is traditionally you say who watches the watchers, but it's not enough to say who's watching the watchers, because then it becomes circular. Who watches the watchers that watch the watchers? You need to have a framework for how you watch the watchers. What are the procedures that ensure accountability or oversight over the regulators themselves? Ultimately, regulators here are the platforms, but you know, the traditional regulators are the watchers of the platforms, so the watchers of the regulators. And we are here. We should be part of this process of watching what's going on and having the appropriate safeguards for that. So thank you very much for that. I'm willing to take questions.